But on to our top story on India Business Hour. India's new bankruptcy law has just been cleared. One major hurdle on its way to becoming an act. The Lok Sabha today passed the bill which paves the way for empowering creditors who right now have often been stuck with a raw end of the deal. So what are some of the salient features of the bill? Let's just highlight that for you. Firstly, the insolvency resolution can be initiated by either party. That's the debtor or its creditors. And once the application has been accepted, no new claims can be pursued against the debtor or its asset for the next 180 days. Now, these assets will be taken over by an insolvency professional tasked with the responsibility of assessing the true value of the assets and the liabilities while ensuring that there are no siphoning off by the debtor. Meanwhile, a parallel process will also kick in, which will see a committee formed by the creditors assessing the possibility of extending further loans to the debtor if they assume that the company can be revived, or else choose the winding up option. Here's another important change, perhaps the most important one envisioned in this bill. On liquidation, the first right over the money will now be going to the workman, who will have to be remunerated for 2 years' pay. Followed by that, the assured creditors will come in, and then the tax authorities will get their due. My colleague Rituparna Bhuyan, in fact, caught up with the Minister of State for Finance, Jayant Sinha, right after the bill was passed, the Lok Sabha. We also caught up with T.K. Vishwanathan, the chairman of the Bankruptcy Law Reforms Committee. Listen into what they had to say.
The risk of going into bankruptcy in many cases will prompt a reorganization in any case. And so, as they say, the risk of hanging concentrates the mind wonderfully.
Right.
So the risk of bankruptcy will concentrate the mind wonderfully for promoters and other creditors to ensure that there is, in fact, a reorganization, prior to bankruptcy. Second, of course, the fact is that the promoter themselves can voluntarily ask for a bankruptcy process, and that also will enable a reorganization if they do believe that they themselves can't restructure in a voluntary way.
It's a great landmark legislation. I think this will improve the credit flow into the market, and it will also people will not depend excessively upon the banks for finance. This is a great thing. People will be able to raise finance from the market, and we are looking at that. And this legislation will be a very important legislation for the entire economy.
So let's understand this further. Is this really the ailment for all the pain in the system? Lata Venkatesh is here to give us an editor's take. Lata, can companies die faster now once the bill becomes an act? What's the relief, tangible relief here?
Well, the intent is great, and the expectation is that some of the ills of the DRT Act, the Debt Recovery Tribunals Act, and the SARFAESI Act have been avoided. But I wouldn't be too sure. Even as I speak, the 4 appellate debt recovery tribunals have not even been appointed. The seats are lying vacant. Where is the guarantee that all the national company law tribunals are going to be appointed? First of all, a huge network has to be created, and then they have to be constantly ensure that the seats are filled. Adjournments are granted endlessly by the debt recovery tribunals. The law even over there stated that a case has to be closed in 180 days. They didn't close. So what happened? Were the tribunals fired? Were they given a KRA that next year they should, close about 30 cases in 3 months, or any such performance standards? Where is the chance that any tribunal will be fired, NCLT tribunal will be fired simply because he has granted 100 adjournments? Every case in the DRT takes 5 years. Has any tribunal been fired for endless adjournments? Where is the guarantee that the NCLT will not be fired or will be given strict standards if they allowed a case to go beyond 180 days? You can set up these timelines, but those timelines will be respected provided those who disobey the timeline are fired. But that hasn't happened. And now, mind you, tribunals are not members of the judiciary. They're all government servants. There is no, parliamentary law. There is no constitution which prevents the government from setting these standards, but nothing has happened so far, which is what gives you so much skepticism about whether the bankruptcy law will work, where the SARFAESI has failed and the DRT has failed. I hope I'm wrong, but the skepticism remains. And then, of course, these orders given by the tribunals can always be set aside by the high courts. Stay orders can be given. So, we have lived through decades of courts and tribunals stymieing one another and promoters deliberately playing all these acts against one another. One hopes it is different, but let's ask superior minds who have either authored this law or who know better. I have with me Mr. Madhukar Umarji, former Chief Legal Advisor of the Indian Banks Association, who was a member of the committee that made the recommendations for the Bankruptcy Act. Mr. Umarji, thank you yet again for joining us. All those questions that I raised, so many, the debt appellate tribunals have not even been appointed. Seats are vacant. Should we be so sure that the National Company Law Tribunals will all be appointed and vacancies will be filled on time?
See, it is already being, the names have been approved. That's what I understand. That the appointments are going to be made shortly. And National Company Law Tribunals are supposed to exercise many other powers under the Companies Act other than insolvency law provisions.
Well, it's a good start, sir, if they've already been appointed, because with the debt recovery tribunals...
Yes, appointed. I'm not sure.
Okay.
They are going to be appointed. That's
Fair
what
enough.
I understand.
Fair enough, sir. I'll just come back to you in a minute. Mr. Harish Salve, the well-known senior Supreme Court advocate, has also joined us on the phone line from London. Mr. Salve, good evening. Thank you very much for joining us. Do you think this law is going to be different from the SARFAESI and the DRT Acts? They also had time limits, but those were violated. Do you think this 180-day time limit under the current law is more likely to be maintained?
See, the problem with the BIFR law was it was a reconstruction law. So even the 180-day time limit is not what made it unworkable. What happened is every company went and took shelter under that law. The rehab proceedings went on and on and on. In the meanwhile, all creditors were put on hold, and that law has not worked out too well ultimately. As we've seen, it led to endless litigation. This is what is the need for India of 2016. Companies which are bust have to be wound up. So you go into an insolvency law, you chase the assets, you wind them up quickly. Otherwise see what ultimately where SARFAESI has gone wrong is the BIFR law. Because banks also don't want to jump the gun if there is some hope of restoring a company. So it's this sort of one cancelling the other, which has created all this problem, apart from certain facts that the courts have, in some cases, being hyper-technical about SARFAESI's procedural requirements, which is a separate problem. So I think this law is a huge positive step. It shows India is coming of age, and it shows India is willing to accept commercial enterprises have to run profitably or be wound up. They can't be run on socialistic patterns that even if you keep losing money, you keep going on and banks keep pumping money and till finally even the bank gets sick.
No, I take your points. We've used these phrases before that we must realize the time value of money. A case that goes on for 5 years for 1,000 crores has already lost another 1,000 crores by way of interest. We have heard these arguments before and done these calculations before. But Mr. Salve, I come back to the same question I asked Mr. Umarji. Is there anything in the law which penalizes anybody if tribunals are not appointed on time? Is there anything in the law which penalizes any of the tribunals if they don't close a case in 180 days? What is the point in giving a time limit of 180 days and nobody is penalized if that 180 days is abrogated?
No, penalize is not going to help. You can't send people to jail. Even that is not going to be a deterrent.
But there is no KRA for a tribunal. A tribunal is appointed by the government.
No, the problem is something else, and which is a far more fundamental problem, which you're rightly alluding to. Our mindset has not changed.
Yes,
the mindset of our government has not changed. The mindset of the banks has not changed. The mindset of the tribunals has not changed. And I'm afraid the mindset of the courts has not changed. So what happens today is you put all these time limits. Members are not appointed in time, so the tribunals become hamstrung in their working. If they are appointed, their facilities are not given in time, so the tribunals are hamstrung. The tribunals also take their job. As we take all other jobs, they are overloaded. There are excessive number of cases. There are insufficient number of members. Lawyers have a habit of asking for adjournments. If a tribunal doesn't give adjournments, it becomes unpopular. It is criticized. All this circus goes on, and then the courts interfere on the most technical, hyper-technical ground. They set aside actions of the authorities. Attitude being, chalo, give him another chance, go back, try your luck again. You know, this, when you work in other countries, you work in the UK, for example, or you see in America, there's no question. These things go crack on. Because everybody takes a broad look and says, if you're bust, go wind up. You know, don't run technical, hyper-technical arguments.
Sir, do you think, sir?
I mean, in India, I'm sorry, I've seen on both sides. What happens when a bank files a suit? It's a standard practice to file a counter suit against the bank saying, you didn't give me more money, therefore you owe me damages.
Okay.
And then that nonsensical trial goes on forever.
Absolutely. No, I know of cases where the promoter creates a tenancy after he knows that the proceedings have been filed, and then the courts say it's the tenant's rights, and therefore it becomes a tenancy
I'm telling
issue.
you, there are two remedies.
Yes, sir.
Apart from the fact, I mean, we can only hope that the government will work with greater alacrity in appointing tribunal members, but there are two things which have to come in India to curb this. Wrong statement must mean a jail sentence, right, like it is everywhere else in the world. Yes. In other parts of the world, people are petrified to make a wrong statement in a court. The roof falls on your head. In India, we blink at falsehoods and say, okay, come back with the correct statement. That's not the way to deal with wrong statements. Point number one. Point number two, in all litigation, costs must follow the event. You run a false defense. If the bank spends 1 crore of rupees on fighting you, you must be put to the costs of 1 crore of rupees and pay the bank's lawyers.
Sir, point taken.
It happens everywhere else. In England, one of the reasons why in international arbitrations we always warn clients. Don't run a faltu ka case in an international arbitration. You will end up not only losing your case, you'll end up paying interest, and you'll end up paying at times hundreds of thousands of pounds, maybe even £1 million by way of cost.
Fair point, sir. Let me put that question and the statements you're making to one of the authors of the law, at least a gentleman who recommended many of the clauses in this bankruptcy law, Mr. Umarji. Mr. Umarji, you heard what Mr. Salve has been saying. Is there anything in the bankruptcy law which will prevent it from going the DRT way, which will ensure that cases will be that companies will be wound up in 180 days or 270 days? Anything in the law which is different?
You see, the law is introducing a transformation of the existing law. Our mindset has always been rehabilitation of sick units, trying to keep them running as far as possible. It should not be closed down. The workman's employment should continue. This is the approach for dealing with stress in any industry or any other business enterprise. Now, this is undergoing a change, and if you are unable to carry on your business and repay your debts, you become insolvent and you have to be closed down. Either you prepare a scheme which is acceptable to all the creditors, and if they approve it, that scheme will be implemented. If it is not approved by the creditors, you will close down. Now, you see that this change of mindset will not come overnight. It's going to take time. But at the same time, we have to make a beginning somewhere. So just because it is not likely to be implemented immediately and all that, we can't say that we don't want to reform.
No, I take your point.
The reform is that so that the courts will also have to understand this philosophy behind enacting this law,
yes,
and implement it accordingly.
Take your point, Mr.
And carry out the objects of the law in passing orders when such cases come before them.
Take your point, sir. We'll wind up this discussion. Mr. Umarji, I know you wrote the law and made the recommendations with the highest standards and of ideals and expectations. One hopes it's implemented in the same spirit. Mr. Salve, thank you very much for joining us in this discussion.